Okay, relocation. If you want to take your child out of the jurisdiction permanently, such as immigration, there is a positive requirement to obtain leave from the court. That's in the Matrimonial Causes Rules, Rule 94. Rule 1. There is no registrar in the family court, so the application can be made directly to a family judge. If the parties agree on relocation, then you can simply file a consent summons for the judge to consider. Usually with the relocation, you can either do it during the divorce. Okay, so in that case, you would ask for sole care and control, and you would apply for relocation at the same time. And if you apply for relocation after the conclusion of the matrimonial proceedings, then you might have to vary the care and control to sole care and control on your side. And then you have the application for relocation. One of your classmates has noticed in your course manual about Rule 94, Sub-Rule 2, but the last time I checked the ordinance, Sub-Rule 2 has been repealed. Okay, there's a paragraph on this in your course manual. So pay attention to this. You might want to update this part on your course manual. And because when you relocate to another jurisdiction with the child will normally stay in that place forever. They don't really come back to Hong Kong. They might for holiday, but for the reason that the child will usually be there for at least half a year or 9 months, I would usually suggest my client, if she was to make an application, to offer very generous access. So for instance, of course, you would have to offer some form of electronic access. And for the summer holiday, for example, because you might not have a long Christmas holiday, I would suggest to my client to offer at least half of the summer holiday, or even 2/3 or the summer holiday as access to the other party. And of course, you would also offer to update on the other party, on the children's situations, including schooling, health, residence, and other things. The legal authority that everybody relies on and cites for relocation application is Pain and Pain. It is an English authority at the Court of Appeal level. There is no House of Law decision or Supreme Court decision above this, so this is the highest authority in English law. For practitioners, we refer to it as the Pain and Pain principles. Okay? In considering whether to grant leave for the parent to take the child out of jurisdiction permanently, apart from the factors we have seen in the so-called welfare checklist, the court would also ask questions specifically relevant to relocation, and these questions and the steps are set out in Pain and Pain. So firstly, the court would ask, is the mother's application, because in Pain and Pain, the applicant is the mother, okay? Is the mother's application genuine in the sense that it is not motivated by some selfish desire to exclude the father from the child's life? Then you would ask if the mother's application is realistic, by which I mean founded on practical proposals, both well-researched and investigated. If the application fails either of these tests, refusal will inevitably follow. So there are actually two questions in question one. Whether the application is genuine without the ulterior motive to exclude the other parent from the life of the child. And you will also ask whether the application is realistic, with practical proposals both well-researched and investigated. So what it suggests is that in making an application, if I was to act for the applicant, I will ask them to decide on, at least you would have to know if you're going to the UK under the new BNO 5+1 scheme, you would at least tell me which city you're going to go. You can't just say I'm going to England. Okay? There's no realistic proposal. It's not well researched or investigated. It's better if you can even confine the scope to a certain catchment or neighborhood in that city. Okay? It's not necessary that you have a house and you're determined to live there, because usually you will have to rent a place. Okay? So at least you tell the judge that you intend to stay in that catchment, in that neighborhood where you can find residence and the environment is very ideal, those sort of things. And remember, from the procedural aspect from last time, there will be an international social welfare officer investigating into such environment as you propose. So if you don't include information on where about you intend to live, how are they supposed to do the investigation? And also, I would suggest my client to research into the schools in the catchment. Usually it goes two ways. You firstly would have a neighborhood you want to stay in, and then in that neighborhood there will be certain schools that the children can be allocated under the public education system. Okay? Or it can be the other way around. You intend to enroll the children into a certain school, typically a private school, and then you would tell the judge about the school, why it is good, and it's good for the benefit of children, and then you would tell the judge that it's a very nice residential neighborhood, it's safe, okay, those sorts of things. You would need details to that extent. So if you can't satisfy these two requirements in question number one, your relocation application will be rejected outright. This is a very minimal you have to show the judge. Okay, assuming these are satisfied, then you will have to look at the opposition of the respondent, in this case the father. Is the opposition motivated by genuine concern for the future of the child's welfare, or is it driven by some ulterior motive? Are you objecting for the sake of objecting because you hate the mother? I've seen a lot in my own cases. What would be the extent of the detriment to him and his future relationship with the child were the application granted? Because you would lose physical contact for at least months. Okay? Assuming there is some sort of physical access during holiday. To what extent would that be offset by extension of the child's relationship with the maternal family and homeland? So this is about contact and connection with the parents and also with the extended family. Okay? What it says is that if the child is moving away with the mother, then naturally the relationship between the father and the child will be less and less. But then could it be compensated if there is extended family from the mother's side in, say, London? Okay. Do you have other family support network to compensate for that loss of connection with the staying party? And then you also consider what would be the impact on the mother, either as the single parent or as a new wife, of a refusal of a realistic proposal. Okay, so in B is about if the relocation application is approved, what would be the detriment suffered by the staying party, the father. And then you also look at the other side of the coin. If the application is rejected, the mother is leaving, what would be the impact on the mother if such application is refused? Is she going to have to go by herself without a child? What would be the impact? And fourth is just the welfare principle. You have to look at all these questions by taking a step back and consider what is in the best interest of the child. So this is the Ping and Ping guideline in the case of Ping and Ping. In Hong Kong, it has been upheld in the case of SMM and TWM at the Court of Appeal level. So the guideline has been adopted as a guideline, a standard guideline in Hong Kong law. The reason why you have these wordings, I saw some of you frowning, about extended family, single parent or as a new wife, these kind of things, is because traditionally relocation is for expats who want to go home. So for instance, you can have a French mother, an English father working in Hong Kong, and then they get a divorce and the French mother wants to go back to France. So she wants to take the child with her. So the French mother would have her French family in France. Okay, that explains the wording in B. To what extent that can be offset by the extent of the child's relationship with the French family and the mother's homeland. Okay, that's what it means. Okay, very straightforward test. In ZJ and XWN, it is an appeal decision on a relocation application. It was held by our Court of Appeal that the guidance in Ping and Ping or SMM or even the welfare checklist, second line, they are simply tools to assist a family judge in making the multifactorial assessment to reach a result which is in the best interest of the child. But that is after taking into account of the potential impacts on the parents. It is a very important decision from the Court of Appeal because it says that Ping and Ping is just a guidance. It's not a matter of strict rule or law that you must apply. The judge can choose to use that tools or not. The deciding factor remains the best interest of the child. But in a relocation background, in that context of a parent moving away, then it's fair to take into account the special situations of the parents. Okay. So as I was just saying, in the past, the applications are usually raised by expats who want to go home upon the end of their marriage and upon their divorce. They want, assuming they love the children, they want to take the children with them. to go home with their maiden family. But in recent year, there are more applications for immigration, especially for the UK, under the BNO 5+1 scheme. Okay, this is different. I'm actually doing a case like that currently. The problem is that Pain and Pain does not fit directly because it's not a typical going home case. The client, if assuming they usually don't have their extended family in a foreign jurisdiction, right? So the lack of family network and support is actually a drawback in such an application. And also because you're not from there, you don't have a background in, say, in the UK. How much do you really know about the environment, the culture, the living situation, education, all sorts of things? Whereas in an expatriate's case, you come from that place, you have lived there for years. Okay? Naturally, you have done some research by your own living. But in a immigration situation, you have to do that kind of research your own. And it's based on computer research or information from your friends who live there. And also, it's the case I'm doing. It's not really for permanent moving because firstly, you're under a visa, right? You don't have citizenship, so it's not permanent in that sense. And my client, she essentially wanted to take the children for the purpose of their education. But in a typical relocation, it's for the purpose for the mother or the father to go home. And then they want to bring the children with them. But in my situation, the application was initiated by the wish of better education of the child. So you will see Pain and Pain does not really apply directly in this situation. So ZJ is important. If the tools are not so applicable, then the judge can choose not to apply the tools in Pain and Pain. Maybe I should cite this case in my application. Usually the case that I have, they will not be approved because they don't fit in Pain and Pain. But in the past year, post-2019, there are more and more applications like this. So I think the court would be more willing to depart from that traditional scenario of going home cases. There is a new judgment from the Court of Appeal level. It's called HNW, husband and wife. Court of Appeal it's a judge decision from this year. The mother plans to relocate to Singapore. The reason is that she has a romantic relationship with this guy who runs a business in Singapore. She has, on evidence, she has some business opportunities in Singapore that is relevant to that gentleman. But there is no promised employment waiting for her to go to Singapore. The extended families of both the mother and the father, including the supporting network of the mother, is in Hong Kong. Okay. The relocation was granted at the family court judge by Judge Malloy, with the effect from the uplifting of the traveling ban between Hong Kong and Singapore. And we all remember the situation with the bubble that burst every single time. At appeal, one of the criticism is that under that order by Judge Malloy, the father was to fly to Singapore the first weekend every month. But with the travel bubble, there are still quarantine requirements, however short it might be, and the bubble might burst, as the pattern has shown. There is also the restriction with vaccination. So there's a lot of uncertainties as to frequent travelings which was anticipated by the judge. But the uncertainties cannot be resolved. So the decision was overturned by the Court of Appeal on appeal by the father. It was said by our CA that the mother's application for relocation was rushed and premature and made during a period with the pandemic, having no end in sight, and normal frequent travel was not possible. Her application for relocation should not have been allowed at this stage. So you can take a look into this case if you're interested. It doesn't say directly, but it seems that the Court of Appeal is indicating that relocation is not appropriate in COVID time because of the traveling restriction. It doesn't say specifically, but it forms part of the background, part of the reasoning for allowing the appeal. Okay? And especially, this is not a typical going home case. So the two features are not going home case and the COVID thing. There are other criticisms, but the bit I think is interesting is COVID. At the time when the case went on to appeal, but the judgment was not yet delivered, everybody in the family practice was really anxious about this Court of Appeal decision. There are a lot of immigration cases, relocation cases, pending, waiting for this CA judgment because of the consideration of COVID-19. We wanted to see how the CA thinks about the travel restriction in a relocation application. So I thought you might be interested. Okay, so that's relocation, very straightforward and simple in terms of law. Okay, worship. I will only mention worship very briefly, just because it is mentioned in the last bit of section 19, subsection 1. Just to give you a concept, I don't think it's in your manual, and hence it's not examinable. Worship is something that is retained to fill the lacuna in the law. This is when the GMO or the MPPO cannot get you the order you want, you might look to the device of worship for help. Worship is an ancient jurisdiction derived from the English sovereign's obligation to protect the person and property of his subjects, including infants and children. So under the concept of worship, the queen is the mother of all the children in her kingdom. And all the children in all the places scattered around the world, of which she remains monarch. So in the old days, that would include Hong Kong. She is not only a parent of all these children, but she exercises, theoretically, the parental care over any children within her jurisdiction. The power, obviously, is not exercised personally by the Queen herself, but it is bestowed upon her Lord Chancellor and is now delegated to her High Court judges. Upon the handover of Hong Kong in 1997, the jurisdiction in the High Court continues, and this is provided in the Basic Law. So worship is given under the inherent jurisdiction of the High Court. It's not in the statute. Any child under the age of 18 may be made a ward of court, irrespective of his nationality or citizenship. The application is by way of a originating summons with supporting affirmation. So when you make this application, there are a few more documents you need to prepare, apart from the typical OS and the affirmation. You need a notice of hearing, and you need a notice to the defendant to tell the court where the child is, if there's any update, then the defendant has to lodge a fresh notice as well. You also need to prepare a memorandum. That is for the Immigration Department of Hong Kong. And it says that the child is not allowed to leave jurisdiction without leave from the court, to prevent the situation that a party attempts to take the ward out of jurisdiction. The child would become the ward of the court as soon as the originating summons is issued. You don't have to wait for the hearing and a decision. Okay? It's a little abstract. I'll give you some more examples to show you how wardship can be utilized. In a wardship, when a child is made a ward of the court acts in a parental, administrative, and inquisitorial manner. So it is not like litigation, where you argue and fight for things for the children. It is more inquisitorial, to protect the best interest of the child. Okay? So the court's role as the parent is that to simply protect and safeguard the interest of the child. It's very broad. Wardship is only for situations where there is a real need for the court to protect the interest of the child. In MMY, it involves a 2-year-old girl who lived with her grandmother in Hong Kong. Both of her parents lived and worked in the mainland China. The parents have given the grandmother a power of attorney, but the grandmother sought to apply for wardship just in case that sometime in the future she may need to exercise the responsibilities of the parents about the child's continuous residence in Hong Kong, education, and medical treatment, just in case. She wants an order saying that she has that right. But the application was dismissed because the parents and the grandmother agreed what is best for the girl, and it said in the judgment that the future is settled for her and she continued to enjoy family's love and affection. There is no real need in this case. There is already a power of attorney, and the court is not treated as a rubber stamp when there is no need of present protection. So it's always these two arguments. When you apply for wardship, you would always say that there is a real need and is urgent. So the child needs the protection of the court. But then, when the court refuses wardship, they will always say that I'm not going to act as a rubber stamp, because there is no problem yet. Any person having a proper interest may apply to make a minor a ward of the court. If the applicant is not the minor's parent, you will need to show the relationship, and you will need good reasons to justify. Now, it's all very confusing, abstract. I'm going to give you examples. I have handled a case of surrogacy before. The parents, there were 2 children. By the way, with surrogacy, if you're going to have 2 children, it's always twins. Okay, by C-section. Otherwise, if you have 2 children being born like 3 days apart, there's obviously an issue. It's impossible, right? So if you're going to have 2 children or 3, they have to be twins. They have to be born on the same day near the same time. Okay, just so you know. the children in that case, they were born to two surrogate mother, respectively, in India. So I think I mentioned this before. Under the Parent and Child Ordinance, the legal mother of both of these children are the surrogate mothers, respectively. So the husband and the wife, they have no rights in relation to the children. They have Canadian passports, and for some reasons, they were able to get Canadian passports for the children in India. They came to Hong Kong. There was some inquiry with immigration. Immigration and police were in some sort of investigation. I don't know what's going on with that. But then the husband and the wife got a divorce. The case was before Judge Malloy. And then she discovered, upon inquiry, that there was some surrogacy arrangement in that case. And that's why the case was transferred up to the Court of First Instance before Queenie Aoyar, Judge Aoyar. And it's a bit technical, but if they want to get parental rights over the children, they would have to apply when they're still husband and wife. Meaning, in a divorce context, if you want to assume that parental rights legally, you have to do it before the decree absolute was granted. The case has dragged on for years and years. And the judge was giving them a last chance to apply under the Parent and Child Ordinance for parental rights. Otherwise, once their marriage is dissolved legally, they can't be the parents of the children in names. The parents are in India, legally speaking. They didn't do it at the end. They're too focused on their fights, and they're not willing to agree to jointly apply for parental rights under the PCO. So it didn't happen. So worship is something is still in place, because in Hong Kong there is no legal parent, so that the children are made wards of the court. The court has made relevant care and control orders to the parents, but they are not the legal parents. In that case, the power is given by the court under the inherent jurisdiction of the High Court. In another case, that was also a very, very sad case. The parties were not divorced, but what happened was that the father died, drowning by accident. Before the death of the father, the children were living with the mother, father, and the paternal grandmother, Amama. But after the husband died, the mother basically took away the children and not allow the grandmother to see the children even. But before that, the grandmother was actually the main carer of the children, because both parents were working. So after the death of her son, she switched from the main carer to knowing nothing about the children. So in that case, she applied for worship in the court. Because when you apply for anything relating to children, the court will inevitably call for a social investigation report. There will inevitably be a social welfare officer, so she would have to, or the mother would have to allow the officer to do home visit, to interview, to see the children. So the report would tell the grandmother how the child is doing. And at the same time, under worship, because without a worship, only the mother has the right, and the grandmother has not been appointed as a guardian upon the death of the father. So the grandmother has no legal right to request to see the child, but under worship, the court can order access to the grandmother. Okay? There's another case. It was a Hong Kong father from a very rich family with a Korean wife. They got a divorce. The wife gave up on basically everything. She didn't care. So the children remained in Hong Kong with the father. The father is a typical do-nothing 二世祖, okay? But he does not get along well with the family. He didn't get kicked out of the family, but he moved out. The thing is, he doesn't have any money. And the children are well taken care of financially by the grandmother, the mother of the father. So the grandmother in this case also applied. She really loved the children. She applied for worship so that she can be granted care and control and access under worship. Otherwise, she has no right at all. She's not a parent. Okay. So it can also arise in a fight between grandparents and the parent. Because initially, when the children were first made wards, that's many years ago, the children were still very young, and the father wasn't a really good father. He was not so capable of taking care of the children. But because the grandmother, she's rich, she's a grandmother, she cares about the children, she has the resources to hire domestic helpers to look after the children, and also hire tutors to help with their homework. And the children they were not doing so well at school at the beginning. And all of these things cannot be offered by the father. And also, he was not a really good father at the time. Okay. There was an attempt from the father's side to deward the children, meaning they want the children to cease to be wards of the court. We thought we were going to win. The grandmother was basically giving up. But then she has changed counsel, and she refused to deward. And in the end, because the children, one of the decisive factors was that the children were about 17. They were about to apply for college, so private tuition was very important to them. And they start to grow strange with the grandmother, and they're getting close with the father. The father has improved in his parenting, but because they really don't mind the little money from the grandparent to help them to get into a good university. So the court was really reluctant to deward the children, and because they're reaching 18 very soon, so it doesn't matter anyways. The guiding principle is best interest, the welfare. There is usually a prescribed period of worship. There is a time limit. The children cease to be wards if the prescribed period expires. But as I said, you can ask to deward. Or on the other hand, you can apply to ask for the period to continue to a further point of time. The effect of wards is that the High Court will step in and become the parent. The High Court takes away the custodial rights, and it can give care and control and access to parents or even a relevant third party, such as a grandmother. Okay? This is just for your interest. These are all the slides. For your assignment, you can, maybe you have to wait until next class to give a full and comprehensive answer. Basically, there are 3 questions in your assignment. The first one is on the main suit, and it also asks you about the relevant procedure and the documents you need. So you can easily score those points based on your course materials. But of course, you have to apply the facts and to discuss which fact you will rely on for divorce in these situations. The second question is on custody and care control. There is a request, so you should treat the mother as a client. There is, these are your client's instructions, and you try your best to fight for their interest, but at the same time, as a lawyer, you would also advise on the prospect of the client successfully securing the order she wants. The way that I would approach this question is that you have to discuss the concept of custody, the concept of care and control, and perhaps access. You know there are a few types of orders you can have. So you want to discuss the differences between these concepts. And I think she wants sole custody, sole care and control, right? So how does a court come to a decision on custody and care and control? You consider different factors. And the sole principle of best interest. So you would discuss about the relevant factors. Don't give me a list, and don't tell me about the welfare checklist being the law. You will fail. You really have to apply the facts. Take a holistic approach, take a global view, and really think about different factors and how they come together in giving you a conclusion. I have a set of, I will give you my own answer. It's based on a real case I have done. Okay? My answer is based on the result of that case, but it's actually something that we have all anticipated when we first received that instruction for the case. So for practitioners, this would be very obvious. That being said, this is not the only correct answer. There is no correct answer in children or even in finance. So even if you reach a different conclusion, it's fine. The key point is that you have to tell me about your analysis, why you think the court would come to your proposed conclusion. Okay? So you don't have to please your client by saying that the court will give you sole custody and sole care and control. You tell them what is likely to happen. The second question has the most weight, and that is because I expect you to really analyze, to really think hard about it. So I hope in doing this assignment, what we discussed last time will make more sense to you, because now you have some facts and context. The third question is about immigration to Canada. The answer is very straightforward, and because the facts are quite limited, you don't have enough facts to actually apply those principles. So it's good enough if you are alert to the procedure, the relevant law, and special things you have to pay attention to in relation to relocation. You don't really have to apply the facts and analyze. Okay. Any questions for the assignment? Or any questions on children so far? We have done 2 lectures, and then we will do domestic violence and abduction. And next week, for this, I think we have 3 classes next week. So on Monday, we will be doing a little bit more on children, but that's also very fast and straightforward, and it's a little bit on domestic violence. So if you're interested, there is a chapter on domestic violence. Short and sweet, it's not very complicated. On Wednesday, we will start on finance. And then it will be next Wednesday, the Wednesday after Christmas, and I've switched that third class on finance onto the 5th of January. So if you have the time this weekend, I would prefer that you read the case of LKW and DD, which I have asked Space to upload to Seoul for you. The only case that if you're not going to read anything, it's the only case you are going to read. I will take you through the judgment next time in a global way. I'm not going to read that judgment for you, okay? It's too long, it contains too much information. So next Wednesday, I'll give you an overview of the finance structure. You would have the basic framework. And then on the class on the 29th, is the class immediately after the Christmas holiday. I will go into details on the finance. So that class, if you don't want to come, it's very advanced family law. If you want to have a little bit taste of law in family law, that's the law. Okay. So far, these things are, I hope, have been easy, simple, and straightforward. It's not complicated at all. The class on the 29th would be a little bit heavy on the law side. Even if you come, I don't expect you to have read or have known these things. Even if you're here, you can just sit back and relax and listen. Okay. I don't think your exams would ask you to go that far, as I would on the 29th. But that's where the litigation in ancillary relief are. And I'll be talking about prenups in that class if you're interested. For the first week of January, the 3rd will be on ADR, Alternative Dispute Resolution. It is an examinable topic, but then it's so simple. There are less than 20 pages in your course manual. I think the lecture, at best, would go for an hour and a half, at best. I think it's only an hour. And I'm mindful that you have a deadline on that day. Okay? If you have my slides, and if you really don't have the time to come, I think that's sufficient. And you also have the course manual. I don't think your exam would go beyond the bounds of that course manual. So it's up to you if you don't want to come to that class. I've previously mentioned that I was thinking of some sort of mock mediation for you, but then I think it might also be too demanding. And then you're tired and exhausted, and it's just after New Year. And you might not be interested. But the problem is that that lecture will be really short. I really cannot squeeze anymore to make it 3 hours. I hope you can understand. Because it's something that, it's kind of a last class. You have all these concepts as a list thrown at your face, but you can't really appreciate it until you actually use those skills and do a mediation yourself. And then you can feel the differences. Okay? So do you have any other views on that lectures, on how you want to do it? I think I've prepared 30-something slides, but I can go through them very, very quickly. If you're all okay, of course we can finish the class really soon, really early that night. Okay, but if you want more, then I'm afraid that I will have to involve you to participate actively in doing a mock. So I assume that you just want a lecture, you want to go home and finish your assignment on the 3rd. I'm cool with that. I hope you're cool with that, because that would be a short lecture. But if you do want to try a mock, then maybe in the second part of the lecture, you should come to me and tell me about that. And I can find some facts for you to prepare a mock mediation. But without that, I will assume that you just want a lecture. And I will let you go really early that night. Earlier than tonight. I hope you don't mind. And then on the 5th, we were doing a little bit more on finance. It's more on the procedure and also in interlocutory applications, which are examinable. The last class is on the 10th of January. My plan is to give you a quick overview of all that we have done. So you have a skeleton, you have a framework to guide your studies for the exams. It's also an occasion for you to ask questions or for me to clarify some points that we have discussed. If you have questions, you can prepare them beforehand and send them to Katrina so I can prepare something for it. Otherwise, I won't prepare extra slides because they will just be duplications. I think it would be too confusing and too much paper for you to deal with. Okay? Unless there is another special topic you want me to talk about, things that we haven't covered in this course. So the last class would be an overview, a revision, and then in the revision class we'll be doing past papers. Okay. For that 10th of January class, I think what I would do is to have a quick look into your revision manual and also the past papers and formulate a structure based on those things. So they're more exam oriented. Okay? Do you have any questions on housekeeping, exams, children so far, main suit, concubinage, nullity? Okay. Okay, if you want to go, you can go. That's all. Thank you. I'll stay here a little bit if you have any questions.